Ladies and gentlemen, a very warm welcome to you this morning. I hope you've all slept well and are ready for another day filled with intellectual property. For this first panel for you this morning on the impact of innovation protection of economic growth, the organizers have decided to have no lawyers on the speaking panel. I'm the only lawyer here, but you can ignore me because I'm just the moderator. So I will get on with it, on with my task of introducing to you the first speaker, who is Elena Andonova, who holds an MBA, so no lawyer again, holds an MBA from the American University in Bulgaria, and is now working for ICIS Enterprise, which is a branch of the Oxford University involved in innovation questions, and especially dealing then with spin-outs and connections with enterprise, universities, SMEs, and even governments. So, please, you have the floor.
Well, thanks, Anselm, for the kind introduction. Just a small correction. I did my MBA at Side Business School, but I'm a graduate of the American University in Bulgaria, where I studied economics. So, well, first of all, I would like to say that it's a great pleasure to be with you at this insightful conference for me. And we're having a really great morning today, lovely sunshine in lovely Riga. So, yeah, it's a great pleasure, and I want to thank the organizers for extending an invitation to ICIS Innovation. So what I'm going to be talking about is the IP, intellectual property commercialization model, which is typical for the University of Oxford. So my presentation will start with a brief introduction on ICIS Innovation. Then I'll be talking about the typical technology transfer process at the university. And if time permits, which I really doubt, which I'm sorry about, I will briefly explain a success story. So, let me start with a little bit of trivia. So, the University of Oxford is the oldest university in the English-speaking world, and it was founded around 12th century. Also, the university is a great platform, and it's excellent in terms of both teaching and research. Now, many Nobel Prize winners and prime ministers in the UK have graduated Oxford, as I'm sure you'll be aware, including the current Prime Minister, David Cameron. Now, in the UK, the University of Oxford has the highest research spending, which is approximately £500 million a year. Now, in terms of European presence, we are actually having the biggest chemistry department in Europe, and we are also #1 in terms of translational medicine, which includes both therapeutics and diagnostics. Now, ICIS Innovation is a company that is a wholly owned subsidiary of the University of Oxford. And it was established back in 1987 with the mission to facilitate transfer of technology from the university to the society and the market, right? Now, one thing that I would like to mention here is that ICIS' role is really to facilitate those academics who wish to engage in commercialization activities. Commercial activities are not mandatory in the University of Oxford. We only provide support, right? Also, we have offices in, obviously, Oxford, and then Hong Kong, Japan, and Spain. So the company is set up, as I mentioned, as a wholly owned subsidiary of the university, and it's a for-profit company. But what we do is reinvest all our profit back to the university so that we can fund commercialization activities and also fund research. We have 3 divisions in ICIS, which are, the first one and the biggest is the ICIS, what we call technology transfer. And this is the team that is really working closely with the academics to help them license their IP, file for patents, license their IP on create spinouts. So this is the pure technology transfer activity. Then we have another division, which is called Oxford University Consulting, and they're gladly supporting academics from the university who want to or wish to engage in consulting activities for industry and the private sector. This team is only providing a service around contract management, and of course they provide liability insurance for the academics and make sure that everything goes smoothly when the academics want to engage in consulting work. And then the third part of ISIS, which I belong to, is called ISIS Enterprise, and this is really the external facing division of the company. So our team is engaged with clients from anywhere around the world and partners that are all based outside the University of Oxford. So we deal with everyone else outside the University of Oxford. And we are a consultancy service that engages with governments, local governments, research organizations, technology transfer networks, patent offices, and pretty much anyone within the innovation ecosystem. And we provide services in intellectual property management, portfolio IP portfolio optimization, capacity building activities, and in-licensing, out-licensing activities, anything to do with innovation management and entrepreneurship as well. So these are the annual statements of ISIS Innovation. So last year we had a turnover of over 14 million pounds. This is a turnover, it excludes obviously any research funding. So these are money that are generated from the three divisions that I mentioned before, from commercialization activities solely. And we have brought back to the University of Oxford just over 6 million pounds. We are a company that has 91 employees, and last year we had 10 new companies created, which includes both spin-outs and startups. So spin-outs being the ones that are engaging with what we call hard intellectual property rights, so companies that needed a patent, and then startups are the ones that are usually software projects, so they're copyrighted. Now, some more numbers here. Last year, we had just over 300 invention disclosures, and we had 92 patents filed on the back of them. Now, I would like to mention here that, obviously, at Oxford, not every invention disclosure ends up with a patent. But whenever we patent, we actually make sure that we have the funding and that we're committed to follow up with a PCT application. So we don't patent only on a national phase level. So patenting is really a strategic decision, so it has to make sense. I also here have to mention that the University of Oxford is very much focused, and half of its research is going into medical and life sciences, right? So these are sectors that are very patents dependent. So we do have a very heavy patent activity to be able to commercialize these inventions. We also had just over 100 licensing deals done with corporations, and we had close to 400 consultancy engagements made between Oxford academics and the private sector. Now, there's been a survey which is published by the WIPO back in 2013, and what it shows is the university's PCT applications activity. So in this ranking, ISIS, or the University of Oxford, came 16. And you'll probably see that most of the universities that are ahead of us are actually based in the US, where you can also patent software, for example. So the patent activity there is very heavy. And then we have a couple of organizations from Korea, Japan, and China ahead of us. Now, I personally believe that the role of the universities really is to create impact, whether it's through its teaching activities or whether it's through its commercialization activities. Ultimately, there has to be impact, whether it's economic or social. Now, commercialization activity is very important to be linked with some strategic economic goals. So last year, what we've done is we hired economics consultancy to calculate or assess the economic impact of ICE's innovation since its inception. So what we found out is that in terms of gross value added, which is really a metric that is looking into the contribution of an individual producer to the economy, we found that we created such value of £264 million in the UK itself, and this also resulted in 3,400 jobs, almost half of which were in Oxfordshire, so very strong local impact. Now we also, as you can see the statistics from the slide, we've done some economic impact elsewhere in Europe, and there have been 150 jobs created in Europe, over 1,000 jobs created in the USA. This is also because we have activity with US licenses, for example, and also we created jobs and gross value added in the rest of the world as well. And I'm very proud to say that last year we were voted at the Global University Venturing Summit a Technology Transfer Unit of the Year. And I think that for the first time a European Technology Transfer Office won, so we were ahead of Stanford and the MITs and the likes. And I must admit that obviously this is an award given for excellence in technology transfer, but we were also very lucky because we had two really great deals last year. So we had this big exit from a company called Nature Motion, which is basically a gaming software provider, which was bought in California by the big gaming company Zynga for just over $500 million in cash. And then we had even, for me, more exciting deal where basically we've done with an invention that is taking blood sample from the pregnant mother, for the pregnant woman, and the blood test can, with 100% validity, tell you whether the fetus might have Down syndrome. So probably for those who are aware of this area, this hasn't happened so far. There are more invasive tests where a mother needs to go through if there is a suspicion of Down syndrome. So this is really a groundbreaking invention. So we licensed this invention to a company in California called Sequenom. And immediately, as it usually happens with great inventions, there were 3 companies that were also based in California, infringing on our patent, right? And they started selling similar products. So Sequenom, of course, decided to go into litigation. And then what Oxford University didn't want to get engaged is all these kind of patent litigation issues, because the university job is not to do that, right? So what we did was we hired an investment bank, I think it was Morgan Stanley, who did a securitization, in a way, of our royalty payments. So Sequenom paid us £15 million in cash on the spot, and we kind of assigned the intellectual property rights to them forever so that they can deal with the patent litigation. So that was kind of very innovative in terms of deal structuring in the world of technology transfer. Now, let's talk a little bit about the technology transfer process, right? So what is technology transfer? This is taking basically new technology from the technology creator and transferring it to the technology consumer, right? So this is what we do. We link industry with academia. The policy on intellectual property rights at the University of Oxford clearly says that the university, as an employer to researchers, staff, students, owns any IP that's generated through the research activities of its employees, right? Now, in the UK, every university can decide what their intellectual property policy would be and what makes sense for their institution. In the case of Oxford, we also, as I reiterated, we do a lot of medical science, which is very heavy in terms of investment needs. So the university feels that they need to get back something from their commercialization activity. So what is important to know, though, is that the university is helping everyone, every academic who wants to commercialize. And if the academics decides to go to the process of technology transfer, then we share the benefits of the proceeds with the academic. So in a typical scenario, income from licensing royalties will, up to a certain threshold, will go straight away to the academic, so the university won't take anything. After a certain threshold, this income will be split between the university, and it's represented by ICES, the department and the academic. Now when it's down to equity sharing in a new spin-out which is being created, we tend to start from 50-50. So 50% goes to the academic, 50% goes to the university. But this is also open to negotiation. So we've seen cases where the academics will come and make an argument that the university didn't invest a significant amount of money or equipment or whatever, and then they kind of feel that they should have more equity. And this has happened. There's been cases where the academic can get up to 80% equity in a new spin-out. In terms of the software, the university takes only 10% equity, and only if the company is incubated in our software incubator. Otherwise, the academic or the researcher, the entrepreneur, has full rights over the startup, right? We also share, obviously, dividends and exit proceeds from spin-out companies. Now, it all starts with a department which is called in Oxford Research Services. They manage the contracts with the research funders, which can be the government, charities, in the UK predominantly industry, as well as the European Commission, for example, right? So these intellectual property rights that are generated, and the research services will be able to advise whether they belong to the university or not. So whatever belongs to the university, they will pass it on to ICES Innovation, right, for possible commercialization activity. And then ICES Innovation is the unit that will be exploring the different routes to market. So this is, as you can see, a typical, what we call technology transfer process, and it's not typical for Oxford University, it's typical around the world. Now, however, the important bit about Oxford is that they support the academic throughout the whole process. So they support the researcher from what we call cradle to grave, or what I prefer to say, from lab to exit, right? So we have very adequately resourced technology transfer office, which we believe is very important because the technology transfer project managers really need to understand both the commercial market and the science. So that's why most of our people actually have PhDs and MBAs. Right. So the technology transfer process, so to speak, really starts with identification of intellectual property rights. So I would like to mention here that we have an internal marketing team, and their job really is to make sure that they're kind of aware what's going on in terms of research at the University of Oxford. So these people will talk regularly to researchers, to senior researchers, heads of department, and try to find out what's the commercialization activity, or rather research activity, and will also make sure that they raise awareness about the activities that ICES is engaged in. Then what we need to understand is obviously who owns the IP, so we do our own internal IP due diligence, and there are mechanisms in place to use. And then at this point, we also need to decide if there is IP coming on the horizon, what's the commercial prospect for this intellectual property. So we do a little bit of evaluation. And what usually happens is, if the experts from ICES Innovation decide to commercialize, and obviously the academic is wishful to do so, right? That's why they approach us, then it's fine. But in the case where we're not sure whether the invention has any commercial prospect, then there is an option to transfer the intellectual property rights to the academic. So the academic could do the commercialization activity themselves. So we're pretty flexible. Now, in terms of these mechanisms for IP ownership that we have in place, well, the University of Oxford, or the research that comes out of it, the IP will be assigned into ICIS Innovation. So ICIS Innovation becomes the new owner of the IP. Then ICIS Innovation straight away will give a license back to the university so that the researcher obviously can use their own IP for further research. And then ICIS Innovation, when transferring this technology, they will license through a transfer agreement into the licensee or into the new company that's being formed in the case of a spin-out. And I would like to reiterate here that this is IP that doesn't belong to another party. If it has come to ICIS Innovation, this means that it belongs to the university. So we almost never assign our intellectual property rights to a licensee. We only transfer. So we can give an exclusive licensing agreement, but it's going to be through the mechanism of transfer because we want to make sure that we are ultimately the owner of the intellectual property rights. Because, for example, the licensee might not meet their contractual obligations. And if we assign and they're already the owner, you know, we lose power and control over it. So we only transfer with very, very rare exceptions, like in the case of this deal with Sequinum, where we really wanted to pass on the patents. Now, as you're probably aware, in terms of protection, there are two types of IP. Hard IP, which includes patents, trademarks, and design rights. So these are intellectual property rights that you need to register for or file application for. And then we have the soft intellectual property rights, including copyright, database right, which is treated similarly to copyright, and trade secrets, right? So in terms of activity, we do mostly patenting, but sometimes we also can deal with the other intellectual property rights as well. And now I would like to mention actually a quick example of a great commercialization opportunity from a non-patent IP. So this particular example is about a questionnaire that has become almost like the gold standard for measuring the health status in a patient with Parkinson's disease. And probably you're aware that there are no blood tests or other diagnostic tools that you can use to measure Parkinson's disease. So basically the only way to do it is through asking the right questions. So there have been this questionnaire of 39 questions that have been invented and validated widely at the University of Oxford. And we have licensed now this questionnaire to over 17 pharmaceutical companies that are using it predominantly during their clinical trials. Now I would like to mention that this questionnaire obviously is free to download for any health professional or academic that wants to use it for academic purposes. So we are obviously licensing and charging only the commercial entities. Right, so you're probably aware that most of the research that comes out of universities is at very early stage, typically, not always, but generally. So there is this concept of a technology readiness level. How many of you have heard about it before, if you don't mind me asking? Oh, good. Great. So basically, all it says is that on a scale from 1 to 10, you can define at which level of development your technology is, right? So usually when research comes out of universities, it's just enough so you can write an academic paper or get a bit of data and file a patent, right? But it's very far from product usually. And then our licensees, they would like to typically license something that is as close to the product, to the market as possible. So there is this, what we call gap in the technology readiness level that needs to be covered. And this is why we need to translate the development of this technology. And we do it by funding a little bit not more research, but maybe a little bit more data needs to be generated, or a proof of concept needs to be put together to validate the invention, right? So I think that the colleague from Munich yesterday described the same phenomenon and called it the valley of death. So to be able to bridge this gap, the academic won't be able to do on their own, so they need support. And ICES has several ways in which we can support them, and usually this is really the provision of a little bit more funding, which is typically called translational funding, and we do it in several ways. So obviously the academic can apply for grants from the UK government through the Wellcome Trust, Technology Strategy Board and other sources. But we have our internal proof of concept funding available. So one of the funds is called the Oxford University Challenge Seed Fund, which was actually set up by a government initiative back probably 15 years ago. And the government gave Oxford £1 million, and then we found some match funding from here and there. And it was structured as an evergreen fund, meaning that all of the proceeds from the commercialization activity that were funded through this proof of concept fund will go back to the proof of concept, so that we can have more money, so we can give more translational funding to more projects. So at the moment, there's been close to 6 million invested in 100 projects, so you can see that the amounts are relatively small, because this is really pre-seed funding we're talking about here. And I think they've invested in close to 33 spin-outs, and they funded 4 projects that ended up in licensing. Now we also have the ICES Angels Network, which is our own network. Yeah, so I need to hurry up. So we have this Angels Network, which is really business angels who want to invest in our spin-outs. They're usually typically local people, and yeah, and they'll get equity proceeds in the spin-outs. And we have another fund called Oxford Invention Fund. Now, very quickly, I'm almost at the end. So once we complete the translational part, we engage into a marketing strategy. This is where we decide whether we're going to license or spin out. And obviously there will be some advantages for licensing, and there will be some advantages for spinning out companies. It's a commercial decision that needs to be made here. Also, I would like to mention that throughout the whole process of transferring technology, we encourage a lot our academics to engage into academic consultancy. So if the academic wishes to stay and does research and doesn't join, for example, their newly created spin-out, they still have the right to provide consulting services to the spin-out. And also it's very important that once we have a contract signed with a licensee, or with a new spin-out that we just created, it's very important that we provide this post-deal support, right? So basically the relationship just starts there. It doesn't finish, it starts there. So just one very curious fact. Last year we decided to hire a professional auditor to check whether our licensing are paying the right royalty fees. So basically, we found out that we were misled really by around £60,000. So it's very important to have this post-deal support in place so that you can chase your licensee and make sure they make the relevant payments and you gather your money. So the last couple of slides really. So what, in our view, are the important elements for successful commercialization from university point of view? We absolutely believe that there has to be a very strong support from senior researchers, rector, president, from the leadership of the university, right? They have to buy into this idea of commercial activities. Also, we believe that obviously the research has to be a very high quality, if possible quantity as well, but that's not always possible. And there has to be institutional practices and policies in place where it's pretty clear who owns the IP and what will be the revenue sharing mechanism for this intellectual property, right? Also, it's absolutely crucial to have access to proof of concept funding, absolutely crucial, and it's widely unavailable, even in places like Europe, unfortunately. Then also we believe that to be able to be successful in commercialization, you need a really adequately equipped technology transfer office with staff that is trained and enough in terms of numbers of manpower. And of course, it's very important to have an access to a very vast commercial network. And what can, last, and I'm finishing, so what can governments do to help? Well, the governments can either remove the obstacles that are in front of universities to do commercial activities. And for example, one thing they can do is they can provide tax structures or guidance on intellectual property ownership. Another thing that they can do is they can actually create also incentives. So, for example, they can fund technology transfer offices and the training of the staff of these offices. They can provide direct cash injections into the seed funds, so the translational funding is available. They can provide also tax incentives for venture capital community and business angels community so that they are incentivized to invest into university spin-outs. So one current scheme in the UK is what they call the Small Enterprise Investment Scheme. So basically what this law says is that as a business angel, you can get all of your tax burden offset by the amount that you invested into a startup, which basically means free money to put into a startup, right? And so far this has been incredibly successful. So, and ultimately governments can give more money to universities and university and research organizations. So that's ICES. Unfortunately, I won't have the time to go through the case study, but thank you very much for listening. And if you have any questions, I'm very happy to take them at the panel discussion or later on during the day. Thank you.
Thank you very much, Ms. Andonova. That was very enlightening. Keep those questions, write them down already so that we have something to do during the discussion afterwards. It is now my pleasure to introduce to you the next speaker, Antonius Tangena, who is president of the European Patent Institute, but in a former life was at Philips Electronics for 30 odd years. And there he was as senior vice principal responsible for the Philips patent portfolio. Currently, aside from working as or acting as the president of the European Patent Institute, he also runs his own firm, Tangena and Vanka. Please, you have the floor.
So, ladies and gentlemen, let me first thank the Latvian Patent Office for inviting me here. I think it's very important that the attention that we give to IP gets broadly known to, say, SMEs, to universities and other people. And as patent attorneys, we gladly contribute to that. What I'd like to do today with you is, maybe I'll get this one, is give you a bit of an overview of what's going on in the world of patents and IP. Give you an introduction, talk about Europe. Is Europe still innovative? Talk a bit about challenges that companies face in this world. Talk about the IP landscape that companies use to create value from intellectual property. And finally, talk about the role of the European patent attorney. Let me start by reminding you why do we have innovation. We have a lot of problems in this world. We have, say, medical problems. We have infrastructure problems. We have problems of creating jobs, creating food for many people. And we need really creative solutions, innovations to solve these problems. But these creative solutions don't come by themselves. We need to have creators, we need to have innovators, and they do these things when they get some form of reward. And I think the IP system really helps these people to get a reward from their innovation. They help our companies to remain competitive and create jobs for people and solve these problems. And they do that, and I think Maaike van Velzen showed that already yesterday, by giving exclusivity, possibilities for cross-licensing, possibilities for joint ventures, possibilities for defending your company against attacks from somebody else. And at the same time, say the publishing of especially patent documents give companies information about where technology is going, where are your competitors going, what are they doing, so that you can get a strategic insight in how to prepare your company for the future. So the IP system is really very useful. The next thing is Europe still innovative? We hear a lot about China and how well it's doing, and the US is doing very well, and the numbers of patents from China go up. But are we still innovative in Europe? Therefore, I looked at what's called the Global Innovation Index. That is an index that is published every year by WIPO. We heard Francis Gurry, he's involved in that. INSEAD, which is a French business school, is involved in that. And Cornell University from New York is involved in that. And what they do every year, they look at 142 economies that are about 95% of the world's GDP. So all the major, say, countries are involved in this index. And they look at about more than 70 parameters, which are grouped in 7 what they call pillars. 5 of these pillars basically give the enablers, so they tell you how well a country enables innovation, and 2 of these pillars are dealing with output. And in the enablers you have to think about, is capital available for companies? How well are universities doing? Do you have enough technical students? There are a lot of things. Is there press freedom, yes or no? How well is, say, the internet developed in a country? So all these things are going into these parameters, and then basically based on that they calculate how well a country is doing in terms of innovation. And the next slide, if it works. Oh, that's 2. The next slide shows this Global Innovation Index as it was recently published for last year. And what you see is that the top 5 countries are all in Europe, all members of the EPC. The first non-European country is the US. You'll see Germany, Japan, you see Latvia 34, and I must remind you there were 142 countries, so doing quite well. China is 29 and is increasing, but the top range is still from Europe. That means we are still doing quite well in terms of innovation. But our challenge really is to make this innovation really transfer it in prosperity for Europe. And that's why the next slide I would like to show you a bit about the challenges that companies face. Kerstin Jona already mentioned it yesterday. We have phases. We have industrial revolutions, basically. The first one was water and wind, mechanization. The second one was electricity. The third one was the digital revolution, and that's where we are in the middle of that. That means washing machines have their own computers inside. But now we're going to the fourth industrial revolution, Industrie 4, as they call it in Germany, which means the connected world, the Internet of Things, meaning a lot of things are working together. And this means this washing machine is not an individual thing, but it is really connected to the energy supplier, and it switches on when there is enough wind power or water power, whatever. So that is the new phase. And what does that mean? It means machines, workpieces, systems are all connected across an entire value chain. They control each other, they communicate with each other. And this means 2 things basically. Interconnection is the one thing, and the second thing is it is done across geographical regions. So we don't have one country where everything is done, but we have suppliers from different countries or suppliers from all over the world. And this again, this means that intellectual property becomes extremely important. If you work together with somebody, you really need to define what is yours and what is his. Otherwise, the the borders become very blurry, and it's like a house. If you don't have the papers that show that you own the house and you invite somebody to live in a room, he might never go out. And if you don't have the papers that show this is my house and my room, he might say, I like it here, I'm going to stay. And you have no way to get him out. So really, the intellectual property system helps to define what is yours and helps you in this interconnected world. At the same time, it shows that professionals in IP are not only necessary for Germany, for France, for the Netherlands, but also for countries like Latvia, the Baltic states. They're very good in software, so they need local people to help them really to exploit their technology, their know-how and their innovation. And I think that is very important. That's a consequence of this fourth industrial revolution. Also, the center of gravity changes a bit. What we see is we get more competition. The US, Japan, Korea, China. Originally, we had companies that were very vertically organized. So one company, remember Philips Lighting, for instance. On one hand, you get in sand and you get in the ore for tungsten, and out go the bulbs, the lamps. That's not the case anymore. Nowadays, companies are organized more horizontal, meaning there is a lot of room for specialist companies. A company like Apple doesn't produce cameras, or doesn't produce GPS sensors, doesn't produce the near-field communication sensors. They buy it from specialist companies, and then even assembly is done not by Apple, but by Flextronics in China. And that means the competitive edge of companies changes from, I can do everything, I can do the production from, say, the basic components up to the end product, to, I know where to get my components, I know where to get the technology. And that is what we call the intellectual economy. So this is the economy as it was, say, 25 years ago. R&D, manufacturing, marketing, sales. You sell your products, you get a profit, and the profit you put back in R&D. Nowadays, the world is completely different. R&D is open. It is open innovation. You work together with others to develop new products. Maybe you sell your ideas. We heard it from Mike yesterday. If you have an interest in the professional area and you can use the same ideas in consumers, why not sell that invention or buy an invention? Manufacturing is different. You don't have to do it yourself. You either outsource, or you source in, or you manufacture for somebody else, if that is your specialty. Marketing and sales. Examples here are, for instance, the Philips logo. Philips didn't make TVs in America for I think 5 to 10 years already now. They're made by Funai, a Japanese company, and Philips licensed the trademark. Other examples are Intel Inside. Dolby. So you license your trademark, you make money with your trademark. So you have a different loop again, or you have a different way of generating, say, value via the intellectual property. And as I said, that's what we call the intellectual economy. And what you see is that this is the highest value in companies. So this is from Ocean Tomo, and it shows that intangibles nowadays make about 75 to 80% of the value of a company. And that's across a lot of industries. So having a factory, having hardware is often a liability. You have to change it, you have to renew it. Whereas if you're flexible, you're outsourcing, the specialist can have the latest developments, and you can use that. And this means we get some what I would call a new landscape, a new IP landscape to create value. Mike already mentioned it yesterday. You have to see how you can create value. One way would be to share IP, which is collaborative IP, enabling technologies, production, test equipment, things the customer doesn't see. You can easily work together in that field. Open innovation is another example. And I showed the trademark of IMEC. IMEC is an example. It's the University of Leuven in Belgium, where they develop new process for the semiconductor industry. And the value is less cost. You develop things easier with less cost. You have better processes because you have more people involved in the research. Less risk. If it goes wrong, you have only paid part of it. So shared IP is really something to consider. The next thing could be free IP. Open source, patent commons, say areas where there are no patents, royalty-free standards. And the way to do this would be that you create a standard, you create a market for people because they can interchange, they can use that standard and build products for that standard and make profit on the products. So even if you give away IP for free, basically the IP is used then to control the standard. If you use my standard, you can use the IP. If you deviate from the standard, I'm sorry, but I'm going to use my IP. So I try to enforce the standard by using the IP. Even though it's free, you can still use it in a very profitable way. Then there is licensed IP or paid IP, mean you get income. Like Dolby, like Windows, like TomTom, navigation systems are not made by BMW or Mercedes. They buy these components from others. And that is what is called paid IP. And then there is the part, even if you have standards, you would like to distinguish yourself from the competition. Because if I have a mobile phone, I'm not going to buy an Apple and Samsung and an LG. I'm going to buy one mobile phone, so I need something to distinguish myself from Apple if I'm Samsung, or the other way around. And that means I have to keep some parts exclusive. And that's, again, the IP system gives you the choice to say, okay, I'm going to bring this as free. This is what I'm going to keep for myself. This is going into the standard, and maybe you get a royalty via a patent pool or whatever. But the IP system gives you handles for that. The things you want to keep exclusive are the things that the customer really sees. The consumer who buys a thing and what makes the difference then. So then that's what you would like to keep for yourself, which would be menus, which would be trademarked, which would be designs. We're not talking about one part of IP. We're talking about the whole spectrum that is useful. Okay, this means we get different flavors of IP exploitation because the exploitation is different. It is exclusive. It is sharing. The focus is different. If you're exclusive, you focus on what makes my product different from the product from somebody else. If you want a license, you really focus on what makes this invention valuable for somebody who wants to take a license. And what I'm going to do it myself doesn't really matter. So the focus is different. You have different type of IP that you use, designs, trademarks, patents. You really look at the total picture. A company like Dolby used the technology to introduce the trademark, and then when the technology changes, you still use the trademark. So have a long-term vision on that. That's very important, I think. What is the role of the patent attorney? I think patent attorneys or maybe should develop more in a first-rate advisor. They're not just somebody who can draft an application and then tell you, here, have a nice application, here's my bill, good luck. There's more to it. Of course, they need to be technical. They need to be able to think with the inventor to get the idea into a patent application. But they also need to have, say, some legal background. I mentioned a lot of things like open innovation, working together, joint developments. In this connected world, you need to define who owns what. So the legal background, the setup of framework for corporations is very important, that the patent attorney knows what to do. If universities work together with companies, we need to know who owns the IP, who gets the IP. That's very important, and it's very important that we define that before really we start doing all the work together, because afterwards everybody wants to have the nice invention, but before that it's much easier to define it. Strategic, I mentioned already. You have to look ahead and see how the world is going to change. Just let me remind you, 5 years ago we didn't have iPads, and now if I look around I see lots of people with iPads. But 5 years ago the world was without iPads. And think 5 years ahead. What will the world look like? What sort of IP do you have to create now to be able to exploit innovation in 5 years from now? That is very important. So that strategic vision is important, and patent attorneys can help you with that because they have the access to, say, all the technology that's available, that's published in patent applications. They can tell you what is going to happen in 5 years, because the first indication of a new technology is always in the patent literature. I remember my daughter is a biologist, and she was doing some research on mosquito nets because she was doing insects, and she had a very, very secret project for a firm they had to do. And she said, this is this firm, and she had to sign contracts. And the next day I could tell her what the secret thing was, because it was published in a patent application. But scientific people always look at scientific literature and not at the patent literature, whereas patent literature often gives a clue where things are going, what's going to happen. So that's very important. And I think, and it's been also, Elena has said that before, patent attorneys need commercial feel. It's no use spending a lot of money, investing a lot of money in IP if you're not going to use it, if you have no idea how you can commercialize it. So creating value is one of the key things, and that's why patent attorneys need to think with people to say, how is the business plan? What makes your company as an SME, for instance, unique, and how are we going to protect that, exploit that by using the IP system as a real tool? So some commercial feel patent attorneys need to have, and I mean commercial feel, of course, for their clients and not just for themselves when they send the bill. But I think that's quite obvious. Now, given the time, let me summarize what I've said. I think the world needs innovation. That's the only way forward, getting out of the problems that we have, but also out of the crisis that we have at this moment. And I think the IP system really helps you in that. It provides incentives for innovators. I think also we in Europe are still the most creative region in the world, and we really need to exploit that. I think the fourth industrial revolution, the connected world, the Internet of Things, really shows us that we are going towards a world of specialists, people who are, saying, unique, who are very good in maybe one or two fields. And it also shows us that we really need people all over Europe. We need patent attorneys, we need IP professionals all over Europe to help really our companies bring out that specialism and make the most out of that specialism. I showed you that the IP system is very flexible. There are many ways that you can use the IP system really to create value, and I think patent attorneys should help people doing that. And that's the last point too. I think patent attorneys are first-rate advisors to help you make the most. And I must say, in Europe maybe not, but the national patent attorneys are also trained in other forms of IP. Not that they would apply for trademarks, but they have to know that you use the whole IP spectrum to get the most out of your innovation. And with that, I'd like to conclude. Thank you for your attention. And if you have questions, I'd be happy to answer them.
Thank you very much, Mr. Tangena, for showing us that the entire IP spectrum is of importance. The next speaker will need this, thank you. And that indeed you have to think strategically not just about one area of IP, but you have to consider all areas of IP. And I have to say, as an educator of patent attorneys, I really think that this is an important message. Patent attorneys need to be trained not just in patent law, but also need to have a healthy vision of the entire field of intellectual property. So, with that said, it is now time to move from patent attorneys and sort of the IP ecosphere to the SMEs and their role in innovation. And for this, we have the next speaker, Dr. Serge Quazzotti, who holds a PhD in chemistry. I told you no lawyers on the panel this morning. And Serge is at the Intellectual Property Institute in Luxembourg and also coordinator of the EU-funded IP Porter project, or iPorter project as it is called. And he's also designated to become the Director General of the new Intellectual Property Institute in Luxembourg. So, you have the floor.
Thank you very much for this kind introduction. And first of all, let me thank the Latvian Presidency and the Patent Office of the Republic of Latvia for inviting me to be part of this panel of distinguished speakers. It's my privilege, and I'm very pleased to be here today. So, the question that I will want to address during the next 15 minutes is how can we support SMEs in making use of the IP system. So we have heard till now a lot of different discussions, and we have seen that in the field of intellectual property there's a certain level of complexity, and now the question is how can we support the 20 million SMEs that are out there in Europe in order to understand what they need to know about the system of intellectual property, and in order to support them, in order to make use of the system to the extent that they need it to run their business. So I will share with you some of our experiences from Luxembourg, but also, as it was already said in the introduction, so we are coordinating the iPorter project, which is a cooperation project which is involving today around 30 national intellectual property offices. So I will also show you some of the outcomes and results from this European cooperation project. So, but first of all, let me briefly introduce you this newly created Intellectual Property Institute in Luxembourg, because it's now during these days that this new institution is officially registered in Luxembourg. So it was decided during summer 2014 by the government of Luxembourg to create this new Intellectual Property Institute, which will work in very close cooperation with the Intellectual Property Office from Luxembourg. And the main missions of this institute will be to develop and to provide IP support to enterprises, to public research organizations, but also to the general public in Luxembourg. So we will develop and provide trainings, and we will, of course, one of the big challenges and missions will be to create awareness about the increasing importance of intellectual property toward these different publics. So even if we create a new institute in Luxembourg, we still have a long experience in this field, and we also have a lot of cooperations. So we are very networked with other offices, and you know that now, since more or less 10 years, we have an enhanced cooperation between the national intellectual property offices in the field of IP support services to SMEs. So there is a cooperation between the national offices beyond the core business of the national offices, which is to take care of registering and making sure that the intellectual property rights are protected. So beyond this core business, the national intellectual property offices are now, since more or less 10 years, cooperating together on the question and with the objective to enhance the support of SMEs in intellectual property. So here you see some examples of initiatives that have been run during the years and where we have specifically been involved. So you see on the left-hand side, LIP, Linking Innovation and Industrial Property, so which was a project that was, so this, the result was a good practice guide which was published in 2003. But I present it to you today because it had a certain success, because it was translated in 7 languages, and we still have demands today for this publication, and we are working on transposing it to an electronic publication. And then we have these 2 EU-funded projects that most of you probably know very well, because all of you have been involved. So this was, since 2008, the IP Europe Aware pilot project, where 20 national IP offices were involved. And in the follow-up project, which is the iPorta project that ended now at the end of 2014, and that resulted in an enhanced cooperation between the national IP offices and in the field of supporting of IP support services. So during my talk, I will now, in the first part, explain a little bit more in detail what we understand, what is behind when we talk about IP support services. Give you some concrete examples, and in the second part, I want specifically to talk about the added value of this transnational cooperation and to show how this transnational experience exchange resulted in getting an enhanced environment, helping us all to better support SMEs in understanding and making use of intellectual property. So we have heard in several speeches yesterday and today that we are facing, we are in a changing world where we are facing several challenges. So we have most of the values are increasingly intangible. We are talking about open innovation system. So there is a crucial need that that all actors in the economic field, and especially SMEs, really make efficient use of the system and understand the system. So the objective that we have to follow when we support SMEs is to provide understanding. So for those, there are a lot of SMEs, and so a lot of studies are telling us that most of the SMEs even don't know anything about IP. So they are not aware about the intellectual property. So first objective will be to provide the understanding what is intellectual property and why is intellectual property for my SMEs. And then to support them in putting into practice intellectual property in the companies. So to support them by to know what is to identify the areas where they own IP, to support them, to protect, to safeguard the intellectual property, to make use of the IP information, and finally to make business with intellectual property, to commercialize, how to commercialize, to license, to buy, to sell IP, and also to how to enforce IP rights. So these are several areas where we need to support SMEs if we want them to put it into practice. So we have different means to achieve this. We have either they can use by their own, or we can use tools that we use in order to help the SME to change something into the company, to put into practice, or we have training. So these are the different means that we have and the different objectives that we follow when we talk about supporting SMEs. Now we know that among all these SMEs out there, they do not all have the same needs. So there are some which are not aware at all that IP is important for them. But on the other hand, we have SMEs which already have IP portfolios and which have more or less advanced practices. And so it's we need first of all to understand what is the need and when and to take the right tool in order to provide answers and to address the identified need. And in order to do so, to understand, to have an organized, structured view on the needs of the different levels of needs, in the IP Europe Aware project we have developed the so-called AIDA scale, which allows us to get a categorized view of on the different needs that exist. So the AIDA model, AIDA is based on a very old marketing model, the AIDA model, and it's nothing else than dividing the different attitudes that a consumer adopts from the moment where he becomes aware of a new product till the moment where he becomes a consumer of the product. So there are different steps that he follows. So this the attention, where he get the attention. In the second step, he get the interest into the new product. Then he get the desire to become a consumer. And the last A is the action, where he really becomes the consumer. So these are these 4 levels. And what we have done, we have just attributed to each of these 4 levels levels of IP practices. So on the left-hand side, you have, for example, practices, you have the SME which never heard about IP. And on the right-hand side, you have the SME which has which perfectly understands and which has perfect practices. And in between, we have different steps. And the idea is to understand on which level the SME stands, and so this model allowed us to better understand what is the level of needs, and secondly, it allowed us to categorize the different tools that are at our disposal in order to make use of the different tools to address the right needs. So now some very practical examples. So this is an example of a tool that was developed based on this AIDA model. So it's a tool that is based on an Excel file. So you have a questionnaire with a series of questions that you ask to your SMEs, and each question you give a quote. And the different quotes will then give rise to different representations, which automatically will indicate you the level on which level of understanding and IP practice this SME stands. This allows you in the second step to then adopt the right measure and the right tool to help this SME. A second example of a tool is coming from the UK, from one of the partners that has cooperated. It is a partner of the UK IP office, which has cooperated in the iPorta project. It's a very easy tool that can be used by an IP office or by anybody else to understand, to help an SME to understand where the different IP titles are integrated into the company. So this is an example of one tool that we have also exchanged during the iPorta project. Now I want to talk a little bit more in detail about this transnational cooperation between national IP offices, so the iPorta project. So run from 2011 to 2014, and it was a follow-up project of the IP Aware project. So we had participants, so national IP offices from 30 different countries, and the objective was to improve IP support of SMEs in Europe. So we had 3 different activities in the iPorta project. So the first one, and each activity was managed by one partner. So the first one was managed by the colleagues from the Hungarian office, and the first activity was to create a repository of all existing tools to provide IP support that all the partners were having, and to organize exchange of experiences between the national office between the national offices by organizing workshops and working groups where the national offices where the owners of the tools trained the other partners to make use of the tools and the services. So the second activity was the website, innovaccess.eu website. That was an activity that was managed by the colleagues from the French office. And the third activity managed by the German colleagues from DPMA was to create a network of the help desks of national offices. And a very important activity in this, within this activity was to organize networking with local stakeholders, so to connect the national offices with business intermediaries on their local level. So we have created cooperation schemes, standardized cooperation schemes that were implemented in the different countries. So now concretely, we have created a toolbox, so a repository of 69 tools, which comprise 69 tools that are made that are at the disposal of all the partners from the network in order to use them for providing IP support. And then we had workshops and working groups on these 4 different topics: so how to reach SMEs, IP management, IP evaluation, and on the topic of enforcement, that was mainly organized in cooperation with the observatory from OHIM. So, and here you see now examples of tools that and which are categorized following the AIDA scale. So on the left-hand side, you have examples of tools which are used to create awareness. So we have, for example, basic information leaflets, or a tool that is used, that was developed by the colleagues from the Danish office, IP Response, and that was transferred and implemented in 4 different countries. So I also want to highlight on the right-hand side, for example, what has been done in the framework of the IP Marketplace, which is also a Danish tool. So due to the iPorta project, we have implemented a linking to this IP Marketplace in 13 different countries. So the IP Marketplace, which was initially a pure national Danish tool, is now linked via the iPorta project in 13 different countries. So this leads me to the sorry, it's not. So I will skip this slide. It's just an example on how we in Luxembourg we have profited from these results of this transnational cooperation, because I must say that most of our developments in Luxembourg have been based during the last years on inspirations that were coming from this cooperation project. So this is just an example where we have adapted the first tool from the Scottish enterprise that I have shown you. Now to the conclusions. So I think what is important if we talk about sustainable IP support is to really have a very clear view on and to focus the services, to have a clear understanding on the different level of IP practices, because SMEs typically do not have very much time. So you really must go straight away to the target, and you have to know what level of needs you're addressing and with what tools. So and then finally, I want to say that. Now following this more or less 7-8 years of experience from transnational cooperation between national intellectual property offices, I can say that altogether we have more or less all the tools that everybody needs to work to support his SMEs. And I think that we can say that the mechanisms that we have implemented through these European corporations proved to be successful for enhancing the environment of support for SMEs. And I look forward to continue the cooperation with national offices, and thank you very much for your attention.
Well, thank you very much, Mr. Quazzotti. Ladies and gentlemen, it's time for Q&A. We've heard about, in this panel on innovation and economic growth, we've heard reassuring words about the EU's or Europe's innovation capacity. And indeed, this is even supported by the OHIM EPO study showing that technology transfer inside of the European Union by and large stays inside of the European Union, benefiting most notably the new member states. I think that was one of the really nice things to read in that study. Yet, also there is some room for concern. We've heard this yesterday in some of the speeches, that one of the biggest challenges in Europe is bridging the valley of death. And indeed, there is a very interesting UK House of Commons report from the Science and Technology Committee in 2013 that identifies this as one of the biggest challenges that we face in Europe. And indeed, the European Commission, as part of its Horizon 2020 initiatives, has highlighted this as one of the problems. So we've heard from the panel on how universities meet that challenge on bridging the valley of death and bringing research to market. We've heard about firms and how they have to be more outward-looking and also looking at IP as an entire spectrum rather than just isolated IP rights, and also thinking strategically on how to deal with IP at various levels, either proprietizing it completely or indeed giving IP away for free if that benefits other initiatives. And we've heard about SMEs and how they need to be supported. They need to become IP aware. But nevertheless, the question also remains, how can they be assisted following up, getting access to money, getting access to funding, or even if we talk about startup companies, how they can have access to large-scale facilities, research, platforms, and the like. So there must be questions from the hall to our speakers, and I would welcome your questions now. Yes.
Okay, my question is to Oxford University and maybe a representative from Luxembourg. You told about selection. From time to time you have to select which projects support further and which stop. And possibly, I assume you also have to evaluate these projects not only up to their quality but also quantitatively. Do you use some specialist software for doing this, like IP score or some other software? Or how do you quantitatively evaluate prospect of these projects or inventions?
Perfect. Is it possible actually to have my presentation back on? Because I have a slide on this. I didn't show the audience. Thank you. Well, the short answer is, thank you for the question. It's actually a very good question. The short answer is no, we don't have any special software. So you've seen that we come across 300 invention disclosures that we need to select projects from. Obviously, we are pretty well resourced because there are around 40, 50 technology transfer project managers that will be splitting those projects, right? But in terms of the criteria that Oxford University is looking into, I'll show you a slide, actually. Okay. Sorry about that. Right, so I was meant to talk about this project from the University of Malta that we helped on. Basically, I don't know if you can see, but the three factors that are really important for us are the market, the protection, and the support. So when we investigate the market, it's very important to answer the questions. Are we talking about invention or technology that is part of a big market or a small niche market? Is it going to be a growing market or is it a shrinking market, right? Sometimes to be able to find out these answers, we'll have to contact companies and industry and see, you know, what is the situation. In terms of the patent, we have to understand the possible protection. Let's say if it's a patent, is it going to be a broad patent or a narrow patent, right? Is it going to be strong, or we have doubts about this? So then we will also look into the internal support. Is it a project that will require a lot of internal support, and is it worth doing it, right? Also, we will look whether there are any existing synergies, for example. Sometimes we will look into criteria like, have we worked with this academic before, and what's the experience? Right, so as you can see, I mean, we don't have any formal project sort of scoring, but these are typical considerations that we'll take into account. Thank you.
Thank you. I can add that within the iPorta project, so the evaluation of IP was also a subject, and so we have different tools and methodologies that has been exchanged, so between Hungarian, Luxembourgish, and also UK partners, and so yeah, so there are different tools that are available for the valuation of IP. So, and so we would be happy to share this with you if you feel that you have a need for this. So feel free to ask.
Can I press you on that issue a little bit further? Valuation of IP remains a very, very problematic issue, especially since there are various methods of valuing IP, and often it's like who is asking, and a different value will come out of this. So what in that respect do you, perhaps the both or the three of you, think about valuation methodologies, and what do you deem most appropriate for a university or an SME or at firm level?
Maybe I can say something about valuation too, how to choose from invention disclosures, basically. I think it's very important that you not only involve, say, the researchers and the patent people, but also the business people. So in any company, I would advise to have the triangle, have the business people there, have the IP people there, and the research people, just to get a good view of what this means, and focus basically on creating value. What invention disclosure could create most value for your business. I think that is the most important issue. I was responsible in Philips for the portfolio. At that time, we had 9,000 ideas every year, and we filed 3,200 applications. So we really needed to sit together with the business and these people and then decide on quite a lot of invention disclosures and basically always value. What does it mean for the business? How useful will it be? And so it's not a matter of talking about inventive step of how good is the invention. No, what will it bring? And based on, of course, a search, whether it should be novel. That is, of course, without novelty you can't file. But if it's novel and there is a good business reason, and then you need the other people really to make up a good patent application, and that can be very useful for the business. Okay, that's...
Well, first, ladies first, and then...
Okay. Well, thank you. I have two actually things to mention, just kind of as an addition. I hope I don't forget them. So one of them is, so how many people are from universities or research organizations here? Can you lift your... Okay, so there aren't that many, but in the case, particularly in the case of the university, right, I speak from research organizations' point of view, it's very important to understand what's your value of the project, of the IP, but the best way to find out is when you're in a negotiation with the licensee. And when the universities don't give warranties by default, right, they cannot guarantee what's the quality of their patent application, what's the quality of their science, et cetera, et cetera. They're not a commercial entity after all, right? So their liabilities are limited, and this always is reflected in the negotiation process. However, when we talk about value of IP, right, so sometimes I've come across scenarios where we have incredible inventions and a very strong patent granted, or a pool of patents, and then we still struggle to find the application for the invention. And it's amazing technology, amazing patent, unchallengeable, but there is absolutely no application, even though it sounds pretty cool. So think always in terms of, as the colleague said, the impact and the applicability. This will reflect the value.
Yes, definitely. It's an extremely complex matter, and there are a lot of methodologies that are existing. And I think we could talk for at least 2 days only on the subject of methodologies. But now from the perspective of a public service provider. So this is a very critical question that is addressed very often by SMEs. So what is the IP worth? What is the patent worth? From this perspective, there are we have addressed this topic in the IPOTA project, and with the objective to talk about methods that we can use to provide a simple answer, an answer that is as simple as possible, but giving the SME a certain feeling about what is the IP worth. And in this context, so you were mentioning the IP score tool. I think this is one tool that is an let's say, an affordable tool from a methodological point of view, but we have other examples of simplified tools that we use in the context of providing a public service.
Can we have one question from the floor? And no doubt this issue will come up again. Can you wait for the microphone for a moment?
Hello. I'm Anselm, representative from Greenex company, pharmaceutical company in Latvia. I've got quite a lot of very good and positive examples and learned quite a lot of new and good things for me personally. Thank you very much. But I have one question that I've observed during the last decade, that quite a lot of useless patents are appearing on the scene. And actually, I feel they are disturbing they are making the things much more difficult for real innovation. Can you comment on that? Because as we previously have observed for academia, there was a pressure to publish. Now we are observing, I think, the pressure to produce patents. And I think it's bad. Thanks.
Well, thank you for that question. Certainly funding structures in R&D and universities are such that there is an incredible push towards patenting. But I have no doubt that our panelists have something to say about that. Please.
Okay, I think first it depends a bit on the area you're in. If you're in pharma, you're looking more for exclusivity, and in that field you know what you want to do, so you file in general less patents. If you file in different areas like telecom, you file quite a lot of patents because you don't know where the world will go. I mentioned the example from the iPad, and in such field where you want to license, where you want to set new standards, you file a lot of patent applications, but the one thing you also do is that you review quite a lot, and you kill them off when you feel they're not valuable anymore. So in Philips, for instance, the average lifetime of patents was 7 years, meaning quite a lot of them never got into the stage that they were granted, but they were options. Basically, seeing where the technology goes is difficult. The future, looking into the future, is very difficult. So you create options, and then you review and you weed out. And in general, if you look at a portfolio of that type, you would see that 10% of the patents really create money. But you need the other 90% to really get the 10%, because you never know beforehand which one is going to fly or which one will come into the standard. So you have to live with this. It is a strategic game you're playing to get the best out of your innovation. That's maybe my remark. I mean, somebody else.
Yeah, maybe I just want to add that there were studies that were made on this points. And the European Commission, they had an expert group, I think it's now more or less 2 years ago, and they have published the results of this. So you have quantitative data on what they called sleeping patterns, and and on the quality also on these different patterns. So I think it was estimated at around 20% of sleeping patterns. But if you are interested, you can go to this publication, and where you will find more detailed figures about this. So I can give you the reference if you want.
Yes, very briefly, because we have one more question and we have coffee as well. So
actually, I have a comment on your remark, Alex Papaderos from the Technische Universität in Munich. I don't think there is a pressure on academia for patenting. It's rather a pressure of commercializing the research results, and there are different stages of development of technology transfer through the patent system within the university. We have Oxford, who are champions. We have probably other universities also in developing countries. We are somewhere in between. So we had also this development from trying to patent everything, and now we have the situation that we patent things that we accept only for commercialization. So I mentioned yesterday the crystal ball that I have in my office. So I don't think that patents from research institutions or bad patents from research institutions is a problem. No, it's rather a development of bad development of patent system, rather from the private sector for patenting almost everything to blog, etc. Thank you.
Elena, yes.
So
Actually, I'm talking really from a university perspective here as opposed to SME, but it's interesting because there is also a little bit of a cultural phenomenon here, and obviously academics are measured against their activity, and this has changed, as you mentioned, from publishing to now patenting, etc. I've come across places like Malaysia where every academic's got like 20 Malaysian patents on their portfolio or something, which is absolutely ridiculous because they sit and nothing happens further, right? So I think that there is a bit of a positive actually feeling here because in the UK there is this excellence in research framework that's been introduced now, and they're looking at how academics are being motivated. So now they're talking about impact, and impact doesn't mean a patent. Patent is an outcome, right? Or output of research work, but it doesn't necessarily mean an impact. So I think the whole kind of cultural, the whole culture is changing, and we'll see academics being more evaluated in other ways, and how their research impacted society, even if there hasn't been any commercial output whatsoever or a patent filed. So I think that this is going to change, but at the moment it does represent a little bit still of a problem.
But you're right, the buzzword is valorization rather than patenting, and that is fundamentally different. So I think there is room for just one more question. Otherwise, who wants to stand in between coffee? So, no one does? Okay, thank you very much. Thank you to the panelists. There are some little presents for you. So, ladies and gentlemen, we now have a coffee break, which is scheduled until 11 o'clock, and I hope to see you back then. Thank you very much.